Ma'am, with the kind permission, can we start?
Yes, please.
Good evening to everyone present here. I am Neet Kaur, member of Sambhav Initiative and moderator for today's session. On behalf of the organizing committee, I extend a warm welcome to our esteemed dignitary, Ms. Varuna Bhandari Gugnani, ma'am, and to all the participants in this 2 weeks National Capacity Building Program on Family Laws, Court Practice Procedure and Drafting, jointly organized by Sambhav Initiative, which is working towards alternative dispute resolution, free legal aid, and creating legal literacy under the direction and guidance of Patron Chief of Sambhav Initiative, Honorable Justice C.K. Thakkar sir, former Judge of Supreme Court of India, and Patron of Sambhav Initiative, Honorable Justice M.R. Shah sir, former Judge of Supreme Court of India, in collaboration with Pro Bono India, which is working towards legal aid and legal literacy. Where today's session is all about alternative dispute resolution in family laws. It is my privilege to have with us and honor to introduce Varuna Bhandari Vignani ma'am, Senior Trainer Mediation and Conciliation Project Committee, Supreme Court of India, and one of the first trained mediators of the Supreme Court of India. With a legal career spanning over 30 years and the past 12 years devoted entirely to mediation, ma'am has made significant contributions to transforming the concept of dispute resolution in India. Ma'am is empaneled as a mediator with the Supreme Court Mediation Center, Punjab and Haryana High Court, Delhi Mediation Center, and Delhi Dispute Resolution Society. Ma'am has conducted over 2,000 mediation cases, including more than 100 matters at the Supreme Court level. Academically, ma'am holds a BA from Kurukshetra University and LLB from Delhi University Campus Law Center and a postgraduate diploma in ADR from the Indian Law Institute, New Delhi, and has completed multiple national certifications in mediation, civil and commercial negotiation, and international dispute resolution from institutions like IICA and IIAM. In the litigation sphere, ma'am has served as panel counsel for the Union of India, the state of Haryana, and various public authorities. Ma'am has appeared in several landmark public interest litigations, including Lakshmi versus Union of India, acid attack survivors, right to education case, PUCL versus Union of India, Safai Karamchari Andolan, and others. Ma'am has also represented Union of India in significant arbitration matters such as Reliance Telecom versus Union of India and Tata Teleservices arbitration before retired Supreme Court judges. Internationally, ma'am is a fellow of the International Academy of Mediators and has contributed to global mediation forums in Singapore, San Francisco, Vancouver, Edinburgh, and was also an organizing member of the Global Pound Conference India Series Chandigarh, a pivotal event in shaping discourse around modern laws for cross border mediation. Ma'am is actively involved in pro bono mediation services, helping underprivileged individuals, NGOs, and communities in need, driven by a strong sense of social responsibility. We are deeply honored to have you with us today, ma'am. Over to you, ma'am.
Yeah, thank you. Thank you for the such a lengthy, I don't even know whether all of it I have done in 35 years of my practice. So, welcome everyone for this session organized by Sambhav Initiative. And it is about it says family laws, court practice, procedure, and drafting. So it is a it this topic is not such a vast topic which can be covered in 1 hour, but I will try to explain, and I can come and take question answers in between with you all if it is necessary. If anybody wants to talk about it, we will be taking the question answers during the session also. You can raise your hand and we can take the question answer in that process. So, so as Kalpesh ji, can you put up the slides?
Yes, Bhavan.
Yeah. So
Yes, ma'am. Yeah. Over to you.
before I think before we go on to the slides, we must understand know the history of the how the families evolved. It was not from the day one that we had the family system. If we go into the ancient times, it was the might is right was the way of life. And if we go back almost 4,000 years back, so there is a study that shows that people cohabited, and it was a group of 30 people, and there was no there were no boundaries between the families. It was like a group of people living together, male and female, and there was no concept of having a family at that point of time. And that was the time when it was through the food was only through hunting. Later on, as time passed and agriculture came into the lives of people, so people tried to settle down. They made small groups, and they were community oriented, and so they made small groups, and that is how a concept of belonging and a family started in the initial days. And as time passed, so the people started to believe and made smaller boundaries with regard to the nature of work they did. And gradually, in the present times, if we look at the definition of a family, so it is to be read as a family is a cohesive group of group connected by marriage, blood, or adoption, forming a singular household with individuals in distinct social roles such as spouses, parents, children, and siblings. Unlike household, which encompasses unrelated individuals sharing a common residence and distinct from a kindred which involves bloodline but may span multiple households. A family is primarily center bound or parent child relationship. In its simple form, a family comprises of an adult and their offspring, with nuclear family typically consisting of married man and woman, their children considered the oldest family structure. So what first and foremost we need to understand what is the definition of family. So the marriage came in the focus, and the structure was that there should be a common bloodline. So and in that common bloodline there can be various group of family people who can husband and wife, their children, then brothers and their children, and then so like 2 3 generations together would be considered as family. So this is taken to be a social group. So as there was division of work, and India being a vast country, so and we have different religions, like Buddhism, and then Christianity, Muhammadan. So they all had different concepts of family. Like in Muhammadan law, like the husband and wife, it is the marriage means that there is a give and take. It is like a civil contract between them. And idea behind the family is that they don't break away. So in their marriage, the consent is taken, and by consent only the marriage takes place. And in case they have to go away from the marriage, they have to pay the meher. so that there can be a divorce or a talaq or a break of of a family. So likewise, in Hindu Marriage Act, there is Saptpadi is taken to be the core of a family. So any marriage that has to be will be taken to be a Hindu marriage only after they have taken Saptpadi as defined in the Hindu Marriage Act. So likewise, if there is a but and the common thing between Hindu marriage and Mohammedan marriage is that they have to have a consent, and the age of marriage is 18 and 21, while in Mohammedan law it is not so specified, but it is taken to be 18 and 21. So and if there is a marriage which takes place from between two different religions, it has to be registered under a special marriage act. So that is for that they have to give a Muhammadan and a Hindu. If they marry is not cannot be taken as a marriage, they have to convert into a same religion, and only then the marriage can take place and a family can be started. So same Buddhism also become is also part of the Hindu Marriage Act. So very interestingly, the Parsis, when they get married, no doubt consent is very important. Without the consent, the marriage cannot take place. Even in Christians, the consent is necessary. Without the consent, the marriage cannot take place. But in Parsis, they have to, the marriage is taken to be marriage for life. There is no concept of divorce either in Hindu Marriage Act or in the Parsi marriages. So the thing is, the idea behind the marriage was to have a group of people who are connected through a common bloodline. And as time grew and the society got divided in their social activities and their commercial and commerce, so the divisions became more visible, and the communities got separated. Like we say that like there are customs there, so there are certain tribes in Himachal and in down south. So there are families which are matriarchal. The head of the family is the wife, the mother. And otherwise, it is most of the Indian culture is of patriarchal society, where the father is taken to be the head of the family. So, so marriage is governed basically in India by customs and the laws available to us. That is Hindu Marriage Act, Muslim Marriage Act, and then Special Marriage Act. And so these are the main acts which govern the matrimonial relationship of the people residing in the country. So an idea was to create a family which is held together and have a social responsibility with against each other. So they and more so the most important thing was to describe their responsibilities, that they will cohabit amongst themselves only. They will not have sex outside the marriage. They will take care of the children, and there will be a provider, and there will be a person who will be in a supportive role. So, so that is how the concept of family came into existence. I hope I am clear so far. So if somebody is not able to understand, please raise your hands and ask. So as time passed and the rise of financial independent, career-focused individuals, both men and women, who are empowered to make autonomous decisions and aspire for individual accomplishments, has significantly contributed to breakdown of joint families. So what happened was that as we say, that women empowerment, and it should be equal rights to everyone, and as the financial independence grew, the joint family system began to break down. And so they were once it started breaking down, so division of property was important. And the other the jewelry and the other movable and immovable assets were to be divided. So the matrimonial disputes came into existence. A matrimonial dispute refers to conflict, disagreement, or legal issues that arise between married individuals or couples. These disputes can be encompasses a wide range of issues, including but not limited to financial matters, difference in lifestyles or values. In communication breakdown or legal aspect related to marriage, such as divorce or separation. Matrimonial disputes are complex and may involve emotional, social, and legal dimension, rooted in various issues such as alcoholism, nicotine addiction, communication breakdown, extramarital affairs, and financial instability. These disputes have to be potential to escalate from the misunderstanding to profound disagreement. Now, let me give you an example over here. I was doing a mediation, and suddenly this girl, she came and she says, "Madam, I cannot live in this marriage because I am in love with my son's classmate father and I want to marry him." So I was like, this was much against my value system. So I had to take a time out of the mediation and go back, think about it, and then come back after 2, 3 days and then sit down, so that my neutrality is not breached and I am not biased by my own value system to address this issue. So as time has passed, with economic independence, with liberal attitude, and so much of technology and social media, so the value system, which was very close held, like with the bloodline, became loose, and it became difficult to live under the same roof. The families had expanded and they were doing different businesses. It was not necessary a person who belongs to a particular community will carry on with that kind of work only. Like if we look at the trader community, so they are the Agarwal and Jain community, or so there is division in India across country. A territorial division is also there. There are like we have 29 states. So they were all culturally different and they have their own tribes and own customs. So there was a lot of difference between the setup, and therefore things tried the relationship got loosened up, and there was the disputes came around as far as property, movable and immovable properties were concerned. So so now uh, uh, and then there was a menace of dowry, which was again a very big problem. See, the concept of dowry was that women did not have the right in the property. So they got their equal right in the property I think it was in the year 2005 or something around that time. I will correct it once once the talk is over. So before that, they had no share in the property, equal share in the property as the sons. So idea was that she should be provided with equal amount of, if not equals, at least some kind of financial security to the daughter, so that when she is married, she should not feel that she was not given right in the immovable property, the land and house. So idea was to give her so many gifts from the family, so which became a big issue. And the another dispute which came in was dowry debts. And section 498 of IPC was introduced, whereby they said any complaint which a woman files, or her family files for cruelty, for asking dowry, or by harming her physically, or she dies of that cruel act by the husband or the family members. So this kind of matter could be reported, and a strict action of arrest would take place, and this was introduced in the year 1983. Okay, so now once 498A was introduced, it became a big weapon in the hands of the family. There were genuine cases of dowry deaths, but there were some people who were taking advantage of these. If they wanted to contest or fight with the family of the husband, they would rope in the entire family, mother, father, brother, sister, and everybody was roped in and cases were filed against them. And the moment the complaint was filed, they were all picked up, and everybody would rush for the anticipatory bail. And huge financial burden used to come on the husband's family and distant family. So this became like a huge misuse of the 498A. So with this huge misuse, gradually the Supreme Court had to water it down, the process, and now on complaint no arrest takes place. And if the family members are not staying with them, all of them cannot be made party to the complaint. It can be only mother-in-law, father-in-law, and the husband who can be immediately made complaint. But after the complaint, it does not mean that immediately there can be an FIR. First, they will investigate, they will be sent for counseling, and then only if they find that there is something, the FIR will be registered. So from extreme harshness of 498A, which was put for a good cause of dowry, prohibiting dowry debts, was watered down because of the misuse of the law. So a family court ordered, there was this matter, Sejabel Bhent Tejasbi Chakravarti versus State of Gujarat. The petitioner, a wife, challenged a family court order alleging desertion by the husband and seeking maintenance under the okay, yes, then there are other disputes under the family the Hindu Marriage Act. That is, the wife is provided with a security, and which is maintenance. So under section 125 of the Criminal Procedure Code, and also under the Hindu Marriage Act, section 25, she can claim for maintenance. So any woman who is who's dependent on the husband, can ask for maintenance. But again, the misuse of these sections led to further watering it down. The latest judgment by Supreme Court is, if there is a able-bodied woman, able-bodied woman who has a education degree to earn, will not be eligible for a maintenance. So see, the things, all these laws were to protect the women who would give up their career, or who were not educated enough, and they were to take care of the family, and the husband was acting as a provider. So these laws were to protect them. But because they were misused, so they were watered down, and now it is for like getting a maintenance in a matter, you have to file a income affidavit of the wife and income affidavit of the husband, and on relying on that, the wife can be given the fixed maintenance for her and the child. For child, of course, there is a provision that there is a report of there is a report in which they have laid down that how there will be a co-parenting. There should not be, a child should not be alienated from the from having a family. So there is a law commission report by which there is a process of co-parenting which is supposed to take place. So women are earning, men are earning. So husband and wife are jointly supposed to bring up the child. The child should not be there to vindicate their stand against each other. So the child cannot be used to vindicate their stands against each other. So the Supreme Court has come very heavily on a child alienation syndrome. I think in 2024, they said there will be counselors. The moment there is a matrimonial dispute, the counselors will be appointed for the children to evaluate that husband and wife are not in any way in any way influencing their mind, so that they do not have a normal childhood, and they develop hatred for the father or the mother. Like couple of days back, we saw it was in social media, where I think a high court judge said that I will give the custody of the child to the father, and you cannot hold the court to ransom to just because you are the mother, to provide you with the custody of the child. So all the laws which were to provide assistance to the real cause, or to sustain the family values and to keep the family together. So because they were misused, so all these they are being watered down and are being controlled by the Supreme Court by passing various judgments, and watering them down to a level where it becomes beneficial for the society, and not as a arm twisting techniques to arm twisting technique to get the money out of the family, or to get the property out of the ancestral property from the husband. So if we see, like there were 2 3 very unfortunate incidents where one child was killed by the mother in Goa, right? So after that, and both husband and wife were CEOs of two different companies. And Supreme Court came down very heavily that no, this is just because there are verticals of maintenance. There is a vertical of divorce. There is a vertical of the visitation and custody. So they cannot be intermingled. They have to be separately dealt with. And a child, uh, when a pregnancy cannot be terminated after 20 weeks, saying that the child has got his rights in the womb, then how does the right of a child disappear once he is born? How can the mother run away with the child or father run away with the child? The parents can, the husband and wife can part ways, but parents cannot leave the child because they have to give him a good runway to take off in life. So the moment the matter comes in the court, the children are sent for counseling to evaluate their psychology, that are they really affected by the separation of the parents or not? Are they wrongly fed by one of the parents with whom they are staying? So there are counselors who are provided in every mediation center for assisting the matrimonial disputes. Uh, Constitutional and legal provisions on mediation and matrimonial disputes. Marriage and family hold immense significance in Indian society, serving as a bedrock or stability of civilization. However, as individuals with varying perspectives and goals come together in marriage, differences inevitably arise over time. These disparities can breed suspicion, selfishness, and resentment, ultimately culminating in marital discord and dispute, such as disputes fueled by divergent interests and attitudes, and can escalate to the point of irreconcilable differences. Conflicts are inherent in marriage, stemming from diverse attributes, backgrounds, and preferences of partners. See, now try and understand. If see, when I started mediation in the year 2000, 2009, so at that given point of time, when the matters came in the mediation, the matrimonial matters, husband and wife were first time married. After few years, we started getting matters where husband was marrying for the second time, wife was marrying for the first time, the girl was marrying for the first time. you know Gradually, as time passed, we started getting matters where husband and wife both had second marriage, and they were not shying away from saying so, that yes, we had a broken marriage earlier and now again we have remarried. At this given point of time, the family disputes or matrimonial dispute is a mainstream profession, legal profession, where you can survive only on matrimonial matters. You are specializing in matrimonial disputes. So and so the so this separate vertical came in. So and this was all because the financial independence was there. They came from different backgrounds. So and as the time has passed, the families have shrunk. The families have only one or two children, they have. So they don't want to leave their parents and go. The parents do get them married, but still that bond does not develop between husband and wife because they are too much attached to their parents, and they are not able to bring them all together as a family, because there is a lot of push and pull, because they are brought up with a different value system and from a different background and from different culture. So they come together, but they are not able to give up and settle down together, because there is lot of financial independence between the families. Causes of matrimonial dispute is nowadays infidelity, domestic violence, control issues, financial disagreement, lack of commitment, and communication breakdowns, and common factors contributing to marital conflict. Infidelity occurring in about one of five divorces. Just look at the number. In one of five divorces is because of the infidelity. As I told you that this girl, she just came and told me in my face that I will not live with this man because I don't love him anymore. So this was not the case when the family system had begun. The definition of family was that people from the same bloodline will live together. So, this is that is what led to. From there, we have come to this. We are looking at a lot of breakdown of marriages. Now, what are the provisions which are available in the matrimonial disputes? So there is section 9, which is the restitution of conjugal rights. So the idea was that once you are married, so in marriage, you will have you will have a single partner, not multiple partners. Then you will live with him and have your children, and both will provide to each other and have a balanced kind of lifestyle. But because of financial independence, it became difficult. But the provision under the Hindu Marriage Act provides that in case there is a dispute, first and foremost, there is a provision which says restitution of conjugal rights, and in which the husband can ask the wife to join the matrimonial home, and wife can also ask the husband to join the matrimonial home. So now there are certain marriages which are taken to be a nullity. So so that is also provided under the Hindu Marriage Act. The nullity of a marriage refers to legal process through which a marriage is declared null and void, essentially rendering it as if it never existed. This can be initiated by an innocent spouse based on various grounds recognized by law. Such grounds may include lack of legal age of marriage. If you are not 18 and 21, 18 years of girl and 21 years of boy, then this marriage is not a legal marriage. It can be nullified. Mental incapacity. If there is some kind of mental disorder that is with the wife or the husband, it can be called a nullity. Violation of prohibited relationship rules. Now, if you see, there is a provision that five, like in Hindu Marriage Act. I am not talking of all, because there are customary marriages in down south where the maternal uncle can get married to the niece. Then in Mohammedan marriages, the first cousins can get married. But in Hindu marriage, five spindas, five from the father side and three from the father side cannot marry each in the family. So that is called spindas. So if any person gets married into the prohibited degree of relationship, then that marriage is a nullity. So then such ground may include lack of legal age of marriage, absence of valid consent. So as I have told you that all the marriages, may it be Buddhist, Hindu, Christian, uh, Parsi, or your Mohammedan marriage, all of them are depending on a consent. If a consent is not taken properly, then that marriage will be no marriage. It will be a nullity. A void marriage is one that is considered invalid from the beginning due to fundamental reasons such as complete barrier to marriage. The reason for declaring a marriage as void or voidable different across various personal laws, including Hindu, Muslim, Christian, Parsi, as I just told you. Uh, so there is another reason where the marriage can be a nullity if the wife is pregnant from at the time of marriage from not the person he's marrying, from somebody else. Then also this marriage is a nullity. Now let us look at the grounds of divorce. They are also explained in section 30 under the Hindu Marriage Act. You cannot simply sit and say that I do not like this man, therefore I am seeking divorce. So there is the ground of divorce is adultery, except under the Muslim law, adultery serves as the basis for divorce and judicial separation, defined as voluntary sexual intercourse with someone other than one's partner. It was formerly punishable under 497 of Indian Penal Code 1860, now invalidated by the Supreme Court. However, it remains valid cause for divorce across all personal laws. So if you are having sexual intercourse with somebody other than your wife, now the amendment that has come is, earlier it was punishable, now it is not punishable, but definitely it is a ground for divorce. Adultery is a ground for divorce. Then is cruelty. Like I told you, 498A was the provision for when the cruelty takes place because of dowry by the wife, by the husband's family, or by the husband. So that would be taken care of by 498A, and under the new IPC, the Indian Penal Code, it will be a different section now. But and then is cruelty, where the husband or the wife is if the wife is refusing to have sexual intercourse with the husband, then also it amounts to cruelty. And if the husband is beating up the wife, or is not speaking to him, or he demeans her, body shames her, is also a reason for seeking a divorce. But then it has to be substantiated with enough evidence. Then is desertion. Acknowledged in nearly all personal laws in India, desertion can be actual or constructive, leading to the termination of spouse relationship. The Hindu Marriage Act, Special Marriage Act, and Parsi Marriage and Divorce Act requires a continuous period of 2 years for desertion to qualify the ground of divorce. Notable, this ground is unavailable to husband under the certain laws, while under Muslim marriage law, a wife can seek a divorce if the husband fails to fulfill the marital obligation for 2 years. So, if you see that sometimes the matters that come to us are that the husband actually just is clocking 2 years of separation and then they file for divorce on the this thing. But the desertion has to be a voluntary act, and they have to be separated for the reason of cruelty. Desertion alone cannot be a ground for divorce. It has to be connected with cruelty. Only then there can be desertion. Just because you just went away from the marriage is not will not be a ground for divorce. Then there is impotency. If in most legal system, impotence or refusal to consummate a marriage are grounds for annulment of voidance under the Special Marriage Act, the Marriage Dissolution Act, and in Indian Divorce Act. In impotence at the time of marriage is ground for annulment if petitioned within a specific time frame, while under the Hindu Marriage Act it leads to annulment. Under the Muslim Act it constitutes ground for divorce. So if there is if so it is intertwined with cruelty. Impotence is so just purely by saying there are times women come up with this, that they do have children and then they are still claiming that the husband is impotent. In these cases they club them with cruelty and then file the cases. Then is venereal disease. Venereal disease served the ground for divorce and judicial separation across various Indian marital laws. The Hindu Marriage Act and Special Marriage Act articulate this ground similarly with the Muslim marriage law, specifically the husband condition with the sexually transmitted disease. So if there is a sexually transmitted disease that happens to the husband, then that is also a ground for divorce. Then it is conversion and apostasy. If he renounces the world, or if the husband or the wife converts into a different religion, then also you can ask for divorce from such person. Failure to carry out the marital obligation in Muslim law, a husband's failure to fulfill marital obligation justifies divorce for the wife. There is a provision called khula where the wife can walk out of the marriage by asking for khula, and she can leave the matrimonial home. And that is the provision provided to the wife in Mohammedan law. Then is irretrievable breakdown of marriage recognized under Indian law. Irretrievable breakdown of occurs if parties fail to comply with the decree of restitution of conjugal rights or judicial separation after 1 year or more. These grounds free parties from material bond. Now, see, there is one provision called that is judicial separation. So what happens is that the husband and wife, they file for judicial separation, that they will try to build up their matrimonial home for 1 year. But if they are not able to, it automatically becomes a ground for divorce. So this is also another thing that we have in Hindu Marriage Act. Then there is divorce by mutual consent. So two parties, after they have completed 1 year of living together, and they feel that there is a breakdown of their relationship, matrimonial relationship, and they do not want to contest each other against each other or malign each other in public, they can move a joint application to the court that we are not able to pull off with the marriage together. Therefore, we want divorce, and the matter can be granted divorce in that case. Then there are provisions for dowry. As I told you, that the dowry was not a bad thing. It originated from the concept that once the daughter will be married, she should have substantial jewelry or cash or some kind of movable assets, so that she can take care of herself in case there is some problem, because she does not care. She will get share in the property from the husband's property, not from the parents' property. So that was the concept of dowry. But then it became a menace, and now it has been further watered down so that the entire family cannot be crucified on a single complaint by the wife. Now, then another act which came into force was after the relationships became so liberal. So even the women who were living with men on promise of marriage in future, or they were for work, they were sharing the household with them. So their status was in a limbo. They did not know, they could not claim anything from such people. So there was an act was enacted, that is Protection of Women from Domestic Violence Act 2005. So this provided them a right of residence in the property where they were living with the person, whether he is a husband or he was a friend or with whom they were having conjugal relationship. So they can claim for right of residence from them. And they so and they any like even calling names or body shaming amounted to a criminal offense, and there could be a punishment against them, though the proceedings are civil proceedings, but it was punishable in under the IPC. Now let us see. Can you change the slide now, please? So see now, next slide. There will be a slide for mediation. Next. Okay, I think we can go back to the first slide. Yeah. So, see now, what happened was so much of litigation. It became a mainstream profession for contesting matrimonial matters. So, the moment a person will come up with a complaint, one of the examples that we give is that the wife came that she's having problem in her matrimonial home, and she gave the facts. So now the lawyer has to put those facts into four corners of law and then file the case. So when the lawyer files the case, he has to win. If he loses, he will not get more matters. So he has to make it so stringent that immediately the husband is picked up. Immediately she starts getting maintenance out of the fear of being picked up, or fear of his parents being picked up or the family being picked up. And then the child was taken away from the custody of the father to so and it became the negotiating point that if you want to meet the child, first pay. So the moment one complaint would come, they will file five cases. One was 125, that is for maintenance. Then maintenance under the under the Hindu Marriage Act, and then 125 CRPC, and then custody, visitation, and cruelty under 498A, and domestic violence. So one complaint would bring in five cases to them, to the lawyers. So it became a web of litigation. There was a huge explosion. So one of the cases, I can tell you, there were 39 cases filed by the wife, and all those cases was settled in mediation in the Supreme Court in one shot. So what happened was that that this explosion of multiple cases arising out of one matrimonial relationship became a menace, and it was affecting the social fabric of our society. We were at one point of time very proud of us, saying that we have only 1% divorce. But today, nobody wants to live together. I told you just now that there were three marriages. After broken marriages, they are coming together. And still they are not able to live together because of their financial independence, not being able to settle with them, and being very small families, and the parents not being able to alienate their relationship with the daughter to or the son to have daughter and son-in-law have a good relationship. So they are in a kind of tug of war amongst themselves with their children. Further, the children are in tug of war, and the sufferer are the children. the grandchildren. So now let us look at the historical perspective of mediation. So if we see if we talk about the history, so we see Krishna, Lord Krishna, as the first original like negotiator or a mediator. We cannot say that it was a real mediator, but it was kind of negotiation. He said, "Ki, give me 7 villages, and it will be a end of the Mahabharata." So this, and it did not happen, you know. And then if you see further, um, that when the like in whatever when we go for our witness, what do we say? हम धर्म से कहेंगे, जो कहेंगे सच कहेंगे. So we relied on the religion, the dharma, to be the perfect virtue from which according to which we would live our relationships, you know. And so that is how the system in the historically we would say that mediation was part of our culture long back. Next slide. So see, the thing is that if have you heard of the story of Akbar and Birbal? There was this there was a child, the two women fighting for one child, and both claiming to be the mother of the child. And so the Birbal said, "Okay, cut the child from the middle and give half and half." And the mother said, "No, I will let her have the child." And the child was given to the real mother. Okay. So the thing is that wisdom, reason, and prudence, which are one of the first originating philosophies of mediation, was part of our Indian society. So if we see that this is how we used to be originally, how the settlements would take place, you know. And if we see, look at Buddhism, it says Santosham Parmam Sukham, that better than 1,000 hollow words is one word that gives you peace, which ever is reflected in the famous Sanskrit code. So the thing is that we were always believing that something that brings peace is the ultimate virtue of life. So, and then as time passed and there was trade and commerce between between the states and between the neighboring countries, so there were principles of justice, equity, and good conscience. Relying on these principles, the matters were resolved. Next slide. So there were different organizations who would rely on justice, equity, and good conscience, wisdom, reason, and prudence to resolve the matters. So when there were family disputes, there were kulas. There was a community. There was a organization called Kula. They dealt with the disputes between the family members and the society, tribes, and caste and races. These disputes were decided by Kula, relying on the basic principles. Then if there were disputes between the artisans, so there was a institution called Shreni who will settle the disputes of these people, again relying on the basic principles of equity, justice, and good conscience, reason, wisdom, and prudence. There was Puga. They dealt with the disputes regarding trade in any branch of trade and commerce. So the traders, the community, if they had a dispute, they would go to a institution called Puga for their settlement. And then was the panchayat system, where 5 wise men would come together and be elected by the villagers, and any dispute in the village would go to them, and in an informal setup, they would sit between them and, relying on the basic principles, help them to resolve their disputes. Next. So see, there is a constitutional promise, delivery of justice at your doorstep in efficient, effective, and affordable manner. This principle, rooted in Article 39A, 14, and 21 of the Indian Constitution, advocates for equal access of justice, emphasizing mediation as an effective non-adversarial path to resolving the dispute. See, now when a petition, now we have seen that Hindu Marriage Act and Parsi Marriage Act or Special Marriage Act, they have their own way of dealing with the dispute, matrimonial disputes. Okay. Now, when, and then domestic violence is there, and then, so these disputes would go to the court. And one case, one complaint will multiply into 5, 6, 7, and I told you 39 cases were filed, right? So there were multiple cases against multiple lawyers and multiple jurisdictions, civil, criminal, and so it became very, very difficult. So when there is a constitutional promise that it would be across board, it would be, justice will be provided. So something was looked into, that something that can provide justice to everyone in an informal manner. Mediation, with it in its focus on restoring relationship and achieving mutual resolution, aligns seamlessly with the promise, bridging gaps within the traditional justice system by providing efficient, personalized solution outside the courtroom. So mediation, let's see the next slide. Now, so now mediation was introduced. Let's look at the next slide. Yeah. So, now let us understand what is mediation. Mediation is a structured process. Now, panchayat is not a structured process. It is relying on the same principle, but mediation is a structured process. There is a joint session, there is a private session, there is then they evaluate, they frame, they come up with their issues, and then the parties themselves come up with the solution, and then the matter is settled. And that settlement is not open to challenge. So it is not like split in half. I'm fighting for one orange. Okay, split it into half, give one to one and to the other, means it is a compromise. It is not mediation. So mediation is a structured process facilitated by a neutral third party. Mediation kya hai? There is a neutral third party who's a mediator, okay, who facilitates. Mediator is not a judge. Mediator is not a counselor. Mediator is not there to suggest. He only facilitates the structured process. Okay. And mediator who assists the parties in conflict, the parties who are fighting. Okay, the husband is in adultery. I want visitation. I want alimony. I want my justice. So they are in conflict to communicate and effectively negotiate. So how does he resolve? He does not impose, he does not suggest. He established communication between parties using communication techniques to effectively negotiate so that they can talk to each other. In a courtroom, you cannot talk to each other. You are two warring parties, and your lawyers are speaking in a formal atmosphere, in a formal uniform, while in mediation, that is not the case. Here, parties decide for themselves, discussing them between themselves, following a structured process with the help of a facilitator who's a neutral person. Okay? And what do they use? They use communication as their tool to resolve their disputes and differences in a time-bound manner. It is under the rules, within 90 days you have to resolve. Under the Mediation Act, you have 180 days to resolve a dispute. So it is a time-bound manner to reach a settlement which is binding. अगर आप एक सेटलमेंट करते हैं मीडिएशन में, it is not open to challenge. It is final. It is binding. You cannot get out of it. It is a consent decree under Order 23, Rule 3 of Civil Procedure Code. Okay, and it is implementable in different jurisdictions. So it is not that like when we are talking of different jurisdictions means like we are signatory to Singapore Convention of Mediation. So the countries who are signatory to that to that convention, so any settlement which is arrived at in those countries can be implemented in all those countries once India ratifies the the model law. It will be part of the community of those countries. Next slide. Now, why do we go for mediation? I hope the mediation definition is clear to everyone. So, why do we go for mediation? Now, if we ask a lawyer that how much time will it take to settle the matter, how much money will be spent, will I get, if I'm asking for 50 lakhs, will I really get 50 lakhs? Can he answer this question? I think the answer is going to be no. But when you are in mediation and you ask the mediator, sir, can you tell me how much time will it take? He'll say 90 days, at best 180 days. Agar we are following the new act. Then how much money will be spent? Madam, these services are court annexed services. They are for free. Okay. But if you are in private mediation, you can cap it with some amount. And then what will be the outcome? Will I get what I'm asking for? Madam, you will get what you will communicate with the other party and come to a settlement. So you will get what both of you want to give to each other. So the mediator is only a facilitator of the process. Okay. So that is the reason why, and then it restores relationships. It not only assists you to resolve the conflict that you have, but it also restores future relationship. In case there is a child, so they can jointly take care of the child. According to, I told you there is a Law Commission report on joint parenting of the child. So they can jointly talk to each other. I can give you two very recent examples, where the husband and wife, they just fell out of love, and after 8 years of marriage, and they were contesting against each other. And the only thing, when they came into mediation, I said, look here, you are both lawyers. Please, do you want this to go public? Or you want to sit down and confidentially resolve this matter? They said, ma'am, we will like to resolve it here in the mediation center. And both of them parted ways in a very, very simple and very, very harmonious way. And today they are the best parents for their child. And there was another matter where in 2019 the matter came in mediation and the mediation failed. It was not successful. And when it went back into went back into the court, so they both went their way and the cases were going on. So in 2024, in Supreme Court they make a small group where they are still connected with the mediator. So I got a call that my son wants to know who is his father. He is now 5 years old. So I said, tell him who's your father. He says, madam, we will like to come back to mediation. I said, you are very welcome. They came back in mediation and they came together. So mediation is a very beautiful process by which you can bring the families together in an amicable way and in a harmonious way. They can part ways, but still be very good parents to the children. To reduce the burden of the court, the adversarial system often leaves behind bitterness and prolonged trauma, especially for the women and children. Now, see, the courts are overburdened with matrimonial matters. As I told you, when we settle one matter, we settle 5 other matters along with it. But when the matters are filed, it is 1 plus 5, that is like 6, 7, 8, 9, 10, what, however many matters they can file, there is no cap to it. So there is huge amount of bitterness. If somebody's mother is picked up, someone's father is picked up, and they are put behind bars, or the husband is put behind bars, there is lot of bitterness. But if they are in mediation, they communicate and resolve. So mediation was recognized as the need of the hour to resolve the family conflict faster, less adversarial, and more human. It is not like you have to go to the court, lead evidence, and then settle. You have to follow the structured process, use communication techniques, and then come to a solution which is final and not open to challenge. In the family context, mediation is to heal relationships. What does mediation do? It heals the relationship. As I gave you 2 examples, which are very recent, that it heals your relationship. Sometimes you can come together, sometimes you will be best parents, even if you have parted ways. Uh, uh, it gives families space to discuss grievances, explore solutions, and reach agreement that work for everyone, especially children. Helps to achieve solutions that are fair, confidential, and focus on the best interest of the families. See, the beauty of the mediation process is these are confidential proceedings. You cannot go and talk about it, because when the mediator makes, please take to the next slide. When the mediator when a mediator makes the opening statement, right? So, in his opening statement, he lays down the ground rules that please be respectful to each other. Emotions are running high, then and do not use bad words. And he explains that this is a voluntary process. You can leave the process anytime, and this does not affect your right to approach the court in any manner. Okay, so that gives them lot of confidence to participate. Okay, so and then you say ki this is confidential process. Whatever you will talk in this mediation will have to be kept confidential. You can discuss it with your lawyer. You can discuss it with your family members, but please do not make it public. So, and likewise, the mediator is also supposed to keep it confidential. And when they go into the private session, whatever the parties disclose in the private session, the mediator tells the other side, well, whatever you will tell me in the private session will not be disclosed to the other side till you allow me to. And in that case, then the parties are very confident to talk to the mediator and look for a solution with him. So let us look at the benefits of mediation. It is a participative process. I told you, parties decide for themselves. They come in joint session, give the facts, they go into private session, vent out their feelings, then come up with the proposals. The proposals are discussed and finalized as they wish it to be finalized. Then it is creative. I told you, in court, there are 5 cases. If they do not go into mediation, one case will be decided once. And let me tell you, in Delhi, in one matter, the case comes only once in 6 months. There is so much of backlog of matrimonial matters. So the thing is that so when you are in a mediation, you can talk of custody, you can talk of maintenance, you can talk of visitation, you can talk of coming together, you can talk of parting ways, all together in a very creative manner. Then the communication. जब हम बात नहीं करते, बात नहीं करने से बातें बनती हैं, और बात करने से बात बन जाती है. So when we have communication with each other, we look for solution. But when you are in the court, you are like warring parties. You cannot talk with each other. So therefore, There cannot be a settlement, there cannot be any communication. So they are only going with what they are thinking or what they are perceiving. Then so then it is it restore relationship, as I told you, that it restores a relationship of the parties. And uh, sorry, so it is a speedy, efficient, and economical process. I told you 90 days or 180 days. Efficient because parties are participating, they want it the outcome faster. And it is economical. When it is court annexed mediation, it is free. And even if it is private mediation, the amount is shared between the parties. It is a informal, cordial and conducive. Informal, you sit with the mediator. You don't have to wear a proper jacket like as a lawyer and go and address my lord. You can call the mediator by first name. You can sir, madam, or whatever you feel like. You can address, but in a very respectful manner. So it is in a very conducive environment, because wherever either it is in the mediation center, which is been provided by the courts, or it can be in mediator's office, or wherever the parties feel neutral, they can go and settle the matter. It is a fair process. The mediator always remains neutral because parties can always leave the mediation. In these opening statement, he explains it is a voluntary process. It does not affect your legal rights in any manner. You can walk away from any time. You can change the mediator. You can request the mediation center to change the mediator. So all of this empowers the parties to go for mediation and settle it in a time bound manner. And there is no appeal. Once a mediated settlement is authenticated by the mediator, it's not open to challenge. Once the settlement goes to the court will not even change, the judge will not even change a comma in the mediated settlement. In case he finds, some terms not to his liking, he can send it back into mediation. And but he cannot change the mediated settlement. It is long term and underlying interest of the parties. Now see, when the parties come into mediation, they are only talking of the prayer. I need visitation, I need my maintenance, I need custody, I need justice. So when it is they're asking for the prayer. But what does the mediator do? It says, okay, these are your problems. Let us see what you really need. What you really need is peace. What you really need is the child gets the love and affection of both the husband and wife. What you need is that you declutter everything and come to a solution which is acceptable to both of you. Why you can't live together, why you can live together, what is the way to look forward. So it is an open discussion where you look for a long term understanding, and look at the real interest of the parties, and not interests which are in the four corners of law, as put in prayer by the lawyer. Now, very interestingly, I was telling you earlier that this girl came and she said, okay, ma'am, this is my problem. So when the petition got ready, and in accordance with law to make it more, winnable case, so a lot of new facts were introduced. And so when he came to read the petition, he said, madam, I did not know that I really went through all this. What I said, I understand, but now I think I was facing a lot of problem in this family. So what is the job of a lawyer is to make it bigger. The problem look very big. And what is the job of the mediator? To make it look smaller and smaller, and look at what is the real cause and how to address it.
But Varuna ma'am, sorry for interruption. We have another session also lined up 7 o'clock.
Okay.
Sorry. Yeah,
Okay,
ma'am.
okay, okay. Let's go to the next slide quickly.
Yes, no problem.
So these are the acts which govern the family disputes in India. There's Family Courts Act, the Dowry Prohibition, the Indecent Representation of Women Prohibition Act, the Commission of Sati Prevention Act. So these are the acts. Next slide. We can go to the next slide. So, the mediation was introduced in the Family Courts Act in 1984. It was enacted to promote the conciliation in family matters and ensure speedy settlement of dispute. Family courts were one of the first to adopt mediation to settle the disputes. The family courts are empowered to employ mediation and conciliation before proceedings with adversarial adjudication. So, Section 9 of the Act makes it duty of the all family courts to endeavor towards the settlement of disputes. So, what happens is the moment the matter goes into the is filed, the judges are duty bound to send the matter first to the counselor. If that fails, they come back, the matter is sent for mediation. If that fails, then they take it further. First, it is mandatory to go for mediation first. This reflects the understanding that the family dispute settlement is always preferred uh, over a judgment. Because what is the outcome of a mediated settlement is what parties want, not what judges give them. In court, judges give them, but in mediation, they get what they want. Next slide. So these are the judicial cases which have affected in the mediation. This is B.S. Joshi versus State of Haryana. The Supreme, one second. Supreme Court held that the proceedings under Section 498A IPC could be quashed under Section 482 CRPC. BNSS, if parties amicably settle their dispute despite the non-compoundable offense. 498 is not a compoundable offense, as we all know. But with this judgment, they permitted that a 498A matter can also be quashed if a settlement is arrived at between the parties. Then Gyan Singh versus State of Punjab, the court reiterated that offences arising from the matrimonial discord could be technically criminal, may be quashed if the settlement serves the ends of justice. Then is Ram Gopal versus State. The courts emphasized the need to allow compoundability in such cases to reduce the burden on the courts. So, these are the cases where the courts have come up have said that though they are criminal in nature, but they can be quashed if the parties arrive at a settlement in the mediation center. Next slide, please. Parental alienation syndrome. I told you that Supreme Court has very firmly come up with this, that the child cannot be held ransom to decide the matrimonial dispute. So, and they want psychological evaluation of the child as soon as the matter comes in the family court. Next slide. Next slide. So, yeah, we can go to any questions. Yeah. So the thing is that a family disputes, a family which has a definition of binding together through bloodline became so difficult to handle because we started to believe in my right should be crystallized. So there was no way that we wanted to settle the matter. So so mediation has been introduced. The Section 89 CPC was amended and mediation was introduced and said that wherever there is a component of settlement, the matters must be sent for mediation arbitration, negotiation, and so this is what how Section 89 was Section 89 was amended, and then was the Family Court Act also, so that the matters are having a component of a settlement, they should be settled. So, any questions with regard to this? I hope I was clear. Yes, please.
Good evening, ma'am. Thank you very much for such an insightful session. I have one question.
Yes,
In a
please.
situation where the wife has filed a petition under DV Act and a petition for maintenance,
Yes,
the
please.
husband has filed for a divorce.
Yes.
Now the wife continues with DV Act and maintenance, but says she will never agree for a divorce. Is it possible that she can manage not to give divorce if she wants? And what will be the recourse with husband?
See, that is the problem. See, mediation is a voluntary process. If they do not wish to participate, then it becomes difficult. But they have to be, the mediator has to be, very insightful, and he should be able to. The matter when goes into mediation, the parties have to understand that it is only time, money, and unpredictability that would be there. So so when it is discussed that your life will be spent in this, then only the parties, the wives, budge from their stance. Otherwise, if we say that in law, no, they do not have any such. They will keep on going ahead with the cases, and from a family court to high court to Supreme Court, it will keep on rotating.
Thank you so much, ma'am. And on behalf of the organizing committee, I extend a sincere gratitude to you, ma'am, for such an enriching session today. We are truly thankful to you, ma'am, for accepting our invitation and also for taking the time to guide and inspire all the participants. Thank you so much, ma'am.
Yeah, thank you.
Thank
Thank
you,
you.
ma'am. Thank you.